Right, hello everyone. It's lovely to see you all. Some familiar faces, also some new ones. So thank you so much for attending this conference looking at cohabitation reform. And welcome to all those who are joining us virtually. So I'm Andy Hayward and I am one of the co-organisers of this event. And it's very much a group effort. So the others involved are the Family Law Reform Now project, and they are Dr. Charlotte Bendel and Rihanna Parveen at Birmingham, Dr. Sharon Thompson at Cardiff, and Dr. Ellen Gordon-Bouvier at Exeter. And they're going to be hosting the final plenary session of today's conference. And they're going to be telling you also about the exciting project that they've got going on with the Family Law Reform Now scheme. The other organisers are Professor Jens Scherpe, who's just moved over to the University of Aalborg in Denmark, so flown over special for this event, and he's the director of a centre there called Northam. And also Dr. Anna Heenan, who's at the Cambridge Family Law Centre, who sadly can't be here in person, but said that they'll be joining virtually. And also I'd like to thank Graham Fraser, Chair of the Resolution Cohab Committee. He's been doing an amazing job rallying the resolution troops. And it's been a real pleasure working with Graham and that committee in trying to bring this conference together. Okay, so the idea really behind this event is to bring together academics, practitioners, policymakers to explore the question of cohabitation reform. And we're delighted that we've got such a varied group of attendees. We also hope that this isn't going to be just an echo chamber and that there's going to be some different perspectives on cohabitation being advanced. So cohab is a hot topic in modern family law. It certainly wasn't the case, and it's arguable that over the past few years, our reform attention and parliamentary time has been spent elsewhere. We've been sorting out the mess that has been civil partnerships. And then more recently, we've been looking at comprehensive no-fault divorce, so the Divorce Dissolution and Separation Act. And so hopefully now, cohabitation reform might be higher up on the legislative to-do list. Now, as you are all aware, cohabitation, it's been discussed since the early 2000s. We've had proposals by the Law Society, Law Commission Sharing Homes, and then obviously the 2007 Law Commission proposal on the financial consequences of relationship breakdown, proposing an opt-out regime with eligibility criteria. But as you know, that proceeded no further. We also had the 2011 Law Commission proposals on intestacy and family provision. We then moved into the parliamentary sphere. We had private members' bills by Mary Cree MP, Lord Leicester, and then also Lord Marks of Henley, who's introduced a cohabitation rights bill on repeated occasions into the House of Lords. But again, not much really has happened. And then more recently, we've had the Women and Equalities inquiry on the rights of cohabiting partners. And they issued their report last summer, calling for the introduction of an opt-out cohabitation regime along the lines of the 2007 Law Commission report, and the immediate introduction of the Law Commission's intestacy proposals. They were rejected by the government, and conscious that this is being recorded, probably the less I say about that government response, the better. But I'm sure throughout the day, we're going to be revisiting it, thinking about it, and how the political climate also influences cohabitation reform. So you'll have the conference brochures, and you'll see that we've got 4 sessions looking at academic and practitioner perspectives on this issue. And then we've got the treat, which is really the final Family Law Reform Now plenary session at the end. So in terms of housekeeping, toilets are on the top floor and to your left as you exit here. And we have been told that there isn't a fire alarm scheduled for today, but if there is, then obviously you need to move outside immediately down the stairs. For those that are savvy and infinitely more savvy than us when it comes to tech and social media, feel free to tweet. We're using the oh so imaginative CohabConf as our hashtag. So feel free to join there. And then without further ado, I'm going to hand over to Professor Geoffrey Willems, who's going to kick off the first session. as I said, infinitely better at technology than me. Alan, can you help? I'm just trying to load up the slides for Jens' online presentation.
Are these your slides? Are they?
Yes, they're on the desktop.
Okay. Oh, sorry. These ones. There we go. Don't know why it keeps.
So thank you, Andrew. And first of all, I want to say hello to the speakers and the audience here at Inner Temple, as to those participating from elsewhere virtually. Then I want to thank Andrew and Jens, as I feel very privileged to introduce the first session of this very promising conference. The session is dedicated to Andrew's and Jens' forthcoming comparative book exploring in great details the legal regulation of de facto relationships in almost 40 jurisdictions. And I also have to thank them for proposing me to write the Belgian chapter. In line with some of their previous projects, the book will feature not only the national reports, but also their own final comparative chapter, putting forward observable trends and models, and most probably suggesting some interesting paths to follow. In a few minutes, they will give us some substantial hints of these comparative findings, and I think we are all looking forward to hearing them. However, before that, I should say a very brief word about them, even if most people here are probably totally familiar with their work. Andrew Hayward is an associate professor at Durham Law School. His main lines of research are related to same-sex marriage and registered partnerships, property of the family home upon separation, and obviously the legal status of de facto relationships. In these matters, he has authored dozens of journal articles and edited several major comparative law books. He is also acting as an advisor for policymakers in the UK and beyond. On a different note, it's worth mentioning that Andy's outstanding teaching has been distinguished by several prizes, including the University Excellence in Learning and Teaching Award. And based on these impressive skills and achievements, he has been invited as a guest professor in several institutions, most notably at UCLouvain, where we can't wait to welcome him again. This is even more so that some concepts put forward by Andrew in the English context, such as the idea of familiarizing property law in view of offering remedies to de facto partners, have recently irrigated the Belgian debate about couple relationships reforms. Jens Scherpe is currently professor of comparative law at Aalborg University in Denmark. He was until very recently professor at the University of Cambridge and is still extraordinary professor at the University of Western Cape. Jens is an unchallenged authority in the field of comparative family law, and his innumerable publications, books, chapters, articles actually covers any imaginable field or subfield of family law, from gender identity recognition to succession private international law. I have a personal favor for the must-read 4-volume series that Jens published in 2016 on the present and future of European family law. Considering all this, it is anything but surprising that Jens has acted as a consultant in several high-profile cases in the UK and other jurisdictions, including the famous Supreme Court case of Radmacher v. Granatino. He's also been invited as guest professor all over the world, and this is really not a figure of speech, but he still paid us a visit in Louvain-la-Neuve a few years ago, and is welcome there anytime. The sooner, the better. And now the floor is yours, and the evidence.
Let's see whether we can get the tech to work. Right. Yes, thank you very much for the introduction and the invitation today. So as you can see, we're having a joint presentation. So that's a bit like a de facto relationship, of course. And when you learn it, you take conscious decisions about that. So you need to choose a basic structure. So we thought, oh, we could ping pong this back and forth, but that is usually very annoying for the audience. Or we could simply have two parts. But we decided to go for what I call the hamburger approach. So, I'm very much the bun, and Andy is very much the meat. I'm hoping I get some pickle I can claim some pickle for myself. So my first job here is to give a general introduction to the project, a bit of a background story, if you so will, and then give a general overview. And now we're trying to see whether this actually works. There we go. And then fill you in on some of the things we find without trying to steal Andy's thunder. So how did we get to the stage where we have a rather big project on comparative de facto laws? So in the beginning, there was this. I'm sorry that this sort of Zoom thing is in front of that. It's actually Rechtsstellung nicht ähnlicher Lebensgemeinschaften, but at least the English title was very visible. So at the beginning of the century, we can say that now, can't we? When I was still working at the Max Planck Institute, I cooked this up with another colleague, Najma Yassari, and having previously worked on a project on the legal recognition of same-sex relationships for the German Ministry of Justice, I thought, I can do this myself. Rather than being the junior. Everyone has this dream of becoming the senior at some point, and when you are, you wish you weren't. And so I felt that this is a pressing topic that needed addressing. But it's a relatively small sample of 12 jurisdictions, unfortunately mostly in German. There are some English chapters in there, which is why we felt justified to actually have an English subtitle as well. And you can see the legal status as already features. Then I fled a country for the first time and ended up in England, first in Oxford and then in Cambridge. And I transitioned in that sense and was lucky to be part of the advisory group for that project. We all know how that ended. And as Andy said, since we're being recorded, enough said. As you all know, the Law Commission provided a very thorough, very well-researched report with recommendations, and the government thanked them and shelved it. So that seems to be the order of the day. Then came this again. So perhaps can we in any way perhaps move this panel? Probably not. Anyway, so it's the future of registered partnerships. So another comparative study. This time we upped the game. There were 16 jurisdictions, and that was published in 2017. So this project focused exclusively. I think it needs to be done on this machine, if at all. In 2017, but it focused exclusively on formalized relationships. So it was not meant to address what we are here to discuss today, namely people who live in informal relationships. So try. So I'm not going to trouble you much with the findings of this study. Yeah. Or can you just move it to yours?
Yeah.
Perfect. So we're not going to trouble you very much with this today. But there's some patterns that I think are important to understand our current project as well. So we did find that in the formalized relationships, there are certain types of relationship recognition, namely one that we call the functional equivalent of marriage. So to provide something that is more or less the same, that was usually a first step into recognition for same-sex couples. Then they were sometimes constructed as true alternatives to marriage, so open to opposite-sex couples who could opt into this. And then we saw some jurisdictions, including Belgium, extending relationships beyond conjugality to include what is often referred to as carer relationships and other forms of relationships. So we were mightily pleased with that project, and frankly, we still are. But we felt this had left a big gap by not addressing cohabitants. So when Andy approached me about doing another comparative project, I agreed after much whinging and playing hard to get and being a bit of a princess. But Andy can be very convincing. So there we are. So that is what happened. So no fancy cover yet. That tells you something about the project as well. Anyway, so when starting on this project, we knew, of course, that the wonderful Commission on European Family Law, CEFL, had already done a comparative study. in this area, and even published principles on European family law regarding property maintenance and succession rights of couples in de facto unions. So it really rolls off the tongue in 2019. And of course, I had my old little study from the past, and we didn't really just want to rehash or copy them. So we decided to go big or go bust, and therefore we went global. I mean, if you want funding for anything, it has to have the word global in it these days. So we went global. And through rather intense research, we first identified the jurisdictions we thought might contribute to comparative work. Then we started looking for colleagues who we thought might be willing and able to write the national reports for their jurisdictions. And we had quite a few more colleagues and few more jurisdictions on our list, but we did have to draw the line somewhere because it wasn't supposed to be a 4-volume project. And of course, not all of the reports actually were submitted in the end, enough said. You will also notice in a minute when we show you the jurisdiction, we have some obvious gaps, particularly with the jurisdictions with an Islamic legal tradition. And that was a conscious choice because we felt that for the purposes of the comparative study, we mainly wanted to stick to jurisdictions where de facto relationships were subject to some legal rules, to some form of recognition beyond the criminal law. And so we were focusing on jurisdictions where cohabitation was socially accepted to a certain degree. And therefore, we felt that these jurisdictions had more to contribute to the comparison in international discussion. Hence, the legal status of de facto relationships, 2023, we are hopeful, but we're not promising anything. It may well be that the production of the book actually takes a bit longer because Intercenture is a very thorough and very well organized publisher, but the typesetting, of course, takes time. So 38 jurisdictions from 6 continents, as you will see later, Antarctica we just could not cover, but other than that, we were there. So this is the first slide of the countries included. So obviously a bit Eurocentric, but that also is explained by the substance of the matter because there's a lot of jurisdictions that actually have legal rules in place there. So I let this hanging and try to fill the time by jabbering on so that you can take in all the wonderful names of our colleagues who very kindly provided their amazing chapters for this. But of course, we went beyond. When you want to go global, you have to mean it. So we've got North and South America, Oceania, and Africa included as well. And you will notice that it says Durham at the bottom because Andy created these slides and because I have no idea how to do this. So we share our incompetence equally as well, but these work well. And Andy also did this. So that is amazing. I was told by my much more PowerPoint savvy wife that you need to have visual points of interest. So here's one. And you will also maybe, if you're very savvy, spot that we couldn't really color Macau red. But it is a jurisdiction that exists. Anyway, it's part of the book. And of course, when we say it's 38 jurisdictions, it's actually more because you see that we have Canada, United States, and Australia covered. And of course, these countries comprise more than one jurisdiction, but we just count them as one for the count of 38, but of course, it covers much more. So terminology-wise, we decided to move away from the term cohabitants that is widely used in Europe and particularly on this island, of course, and use the terms de facto relationships instead, which is the terminology commonly used in Australia and New Zealand. So we went Antipodean. We thought that this term actually covers much better what we were going to work on and also contrasted much better with our previous project because it highlights that this is not a formalized form of relationship, but actually is based on facts. Moreover, of course, most people in marriage, but not all, but most, and other formal relationships do cohabit as well. So you could say that married people are cohabitants. And so we felt that speaking of de facto was actually much more appropriate. So every study, comparative study, faces challenges, but if you go global, then it faces a few more. And so the fact that we went beyond our normal European borders certainly gave us extra challenges. So we were facing rather different social and legal cultures, very different levels of acceptance of relationships outside of marriage, especially with regard to same-sex relationships. In many jurisdictions, it was difficult to draw boundaries between formalized and de facto relationships, because in them, people would simply be elevated to the status of being married by the virtue of them living together. So the common law marriage myth is very much alive in various mutated forms in some jurisdictions. We then, of course, had to limit the topic a bit to keep it manageable. So we limited this to conjugal relationships of two persons, which was a difficult decision because we found non-conjugal relationship recognition and indeed relationships of more than two persons equally fascinating. So that may be a project for the future. Regarding the substance of the legal recognition, we knew when we started that one of the key problems for this area of law is the inevitable interconnectivity of qualifying criteria and remedies, because they basically bounce off each other. So we really needed to make sure when starting to create the structure of the project that we have this in. And I'm very pleased I passed these 2 points to Andy today for the presentation. And finally, and this is all I'm going to say on this, during the project, we encountered very different approaches to legal scholarship, to put it tactfully, across the globe, as cultural differences, of course, not only extend to the legal system as such, but also to the way that scholars engage with it. And that doesn't mean that one is better than the other, that there's a hierarchy, it's just different. And the challenge for us was, of course, that we come from a very Western background, very European way of thinking. And our task was to make sure that our colleagues who function in a different way can contribute in the way that they see fit, but at the same time also enabling us to run this project as we needed to. So we had to engage in a significant cultural detachment exercise and question our way of thinking all the time, and we hope that this succeeded. A very common way of dealing with comparative projects, and the one that I tend to use, is the questionnaire approach. And this, of course, is not without critics. But that means that we handed our contributors a fairly detailed questionnaire, which after some prodding, they actually also read, and some of them even properly engaged with. But the idea of the questionnaire approach is that we collect the information that we actually need for our comparison. And the importance of a well-designed questionnaire cannot be underestimated, as it's absolutely essential to detach oneself from one's own legal system, from one's own legal way of thinking when drafting the questionnaire. So in doing so, it's necessary to get a level of abstraction that allows people from very different legal systems to work with the same questions. So in a nutshell, the challenge was to be broad enough and narrow enough at the same time. And that's a very delicate balancing act, to say the least. I've been part of comparative projects which had 13 questions, 12 of which I had to say not applicable. So that is not a good questionnaire. So we really worked hard on this. So on the slide here, you can see the core structure of the questionnaire, or the super headings, if you will. There were, of course, many subheadings and much more detailed points, but I will not trouble you with that because my PowerPoint savvy wife says not too much text on one slide. And I listen to my wife always. Hello, if you're listening. I'm on record. So for today's hamburger presentation, with me being the bun, we will follow the super heading structure. So I'll just give a quick overview now, and then poor Andy has to be the meat. We will not discuss the last point, current problems and debates, because we think that will come up in the discussions. Right, so I have the rather daunting task of giving you the overview, and I have to seek refuge in broad generalizations, or more positively inclined categorizations, perhaps. And for this, I will extremely shamelessly, but with permission, borrow a slide from my amazing colleague, Joe Miles, who is also in certain circles worldwide known as Miss Cohabitation. And that is her slide, it's all hers. Right. So essentially, the categorization of approaches for the recognition of relationships outside of marriage is guided by two very basic policy considerations. And the first is, should a formal act be required? Now, as already said, should this be an opt-in? Should a formalization be there? And that, of course, is our previous project, so I will not discuss that side of the schemes today. But, and that's a crucial comparative finding from the previous project as well, and what can be observed is that the opt-in approach, the idea that you can solve the problems of couples living together without being married by having an opt-in scheme, is an utter, total, and complete failure if you actually want to provide remedies for all people who are outside of living together without being married. because unsurprisingly, in all jurisdictions that have such regimes, there are still many, many de facto couples who do not opt in for a variety of reasons. We're going to hear about those later, so I'm not going to go into that. And of course, the problems of these legal problems need to be addressed. So there's a plethora of evidence that where opt-in regimes exist, then further legal rules on de facto couples have to be developed out of necessity, either by the judiciary or by piecemeal legislation. We have been unable to gather for the previous project and this one to gather reliable and comprehensive data on the socio-economic background of those that do and those who do not opt into the formal regimes, but anecdotal evidence certainly suggests that registration schemes or formal schemes attract better educated people, legally aware people, and certainly more affluent couples. And therefore, it seems that the registration schemes very much attract those who don't really need the protection the least and leave those outside who need the protection the most. The second big policy consideration, and much more important for today's topic, is should the legal consequences of relationship recognition be similar to those of marriage, or should they be different? Now, that, of course, is a pure policy decision, and it depends on many factors, and therefore, in itself and by itself, does not really make fertile ground for comparison. But it's interesting to note that both approaches can be observed, and that the dividing lines between those who've chosen one or the other, or something in between, are not necessarily the ones that you would expect. So, for example, Sweden operates a scheme that is distinctly different from marriage, which is somewhat surprising given the egalitarian society in which they proudly are. They proudly promote that all family forms are equal, everything is acceptable, everything should be given, the possibility to choose their lives, and there's a clear majority of children born outside of marriage as a result. But the scheme is distinctly different from marriage, and there are actually very limited remedies in case of separation of de facto couples. The latter is also true for France, for example, which, like Germany, Belgium, or the Netherlands, does not have a proper legal framework for de facto relationships at all. So by contrast, the legal responses in New Zealand, which we're going to hear about later, Australia, and jurisdictions that are on the territory of what once was Yugoslavia, but also Japan, more or less equate de facto relationships with marriage for very different reasons, interestingly, and only provided, of course, that certain requirements are fulfilled. In other jurisdictions, elevating the relationship to be a marriage in substance, in some cases even in form, is the only legal response available. And the latter very often has cultural and social reasons, namely that marriage still is the only acceptable family form, full stop. And so if you wanted to recognize de facto relationships, then the only way you can do so is by turning them into a married couple, essentially. In some jurisdictions also, if you are left as either the survivor or the left person in at the end of a de facto relationships, you're seeing as damaged goods, no longer acceptable for society, and therefore you should have damages claims, and so on. So I will not venture further into this. That's what Andy will be talking about. So just a few words on the underlying debates and policies. So one of the key battles is between the perceived need to protect autonomy on the one hand and the need to protect the economically weaker and indeed socially weaker party very often on the other. And the more weight you give to the autonomy argument, the less protection you will be able to offer to the scheme in question and vice versa. And you can observe this in the national reports. The perceived need to protect the traditional family is another recurring theme, at least in some jurisdictions, but framed in another way. The argument is not protecting the traditional family. It really is that marriage is the preferred and better family form for those who promote this. And therefore, the privileges of that institution must be maintained. The sacrifice for this, of course, is made by those who do not or cannot access the wonderful and preferable legal regime for whatever reason. So in my university lectures, I usually call this sacrificing the de facto partners and their children on the high altar of marriage. And then there's a bloody picture. So again, I'm not going to say more about this. We're going to hear about this later today. So to conclude this overview, what has really struck me is that some jurisdictions, which usually are the common law jurisdictions actually, where the remedies in case of divorce are broadly discretionary, like England, Wales, and Hong Kong, and so on, that there the preservation of the traditional family argument is quite prominent when denying de facto couples rights and remedies. But So, but given that the Facto did not make a formal commitment, this could be one of the circumstances taking into account when having a discretionary exercise. So discretionary remedies actually lend themselves to that. So I always found it a bit odd that in those jurisdictions there is a limit of flexibility. And indeed, the discretionary nature of the remedies is often seen as a strength in those jurisdictions which offer comprehensive recognition of de facto couples, like the Australian jurisdictions. For most civil law jurisdictions, things are rather different. There's a different nature because in the civil law jurisdictions, as most of you of course know, there usually are matrimonial property regimes, or as we probably should call them in the future, family property regimes, with more or less precise rules regarding the division of property in case of divorce. So for them, the questions therefore are, should we extend this directly to de facto couples? And if you do, that would amount to saying that all qualifying de facto couples actually, should be treated to the same kind of relationship recognition. And that can, of course, be problematic given the diversity of this group. But because the remedies for marriage are not discretionary, and the idea that property remedies should be discretionary is utterly alien to the civil law mind, we are running into some difficulties here. And that means that in those jurisdictions, we usually fiddle with the qualifying criteria in order to make sure that only the right kind of people are included if we then actually have an equation with marriage. And if we don't want the equation with marriage, then we're fiddling with the remedies, so that they actually get different remedies, so that we don't foist these rules upon them that we seem to think is only appropriate for marriage. So I don't want to steal Andy's thunder any further. He will now continue with his part of the presentation. So welcome to the meet.
Thanks, Jens, and thanks, Geoffrey, for the introduction. I'm not sure how meaty this will actually be, but I'm going to be basically focusing on 3 areas of the questionnaire. So looking at the qualifying criteria, the legal effects during the relationship, and then the legal effects upon separation. I did break the rule that Jens's wife has said in relation to too much text on the slide, so apologies for this. So as Jens said, we've got 38 jurisdictions, but he was right to mention some jurisdictions are quite numerous in terms of the different state laws. So I did feel sorry for the USA contributors who effectively had 50 different de facto regimes to look at. Okay, so what I'm going to look at here, first of all, is the definition and eligibility, and we draw this distinction between the two. So essentially, we've got a small number of jurisdictions that do have comprehensive statutory definitions of de facto. And then in addition, they have eligibility criteria. So the definition deals with more ephemeral qualities of the relationship. And then we look to the eligibility criteria, and that's looking more at specific acts that are done. So often we're looking at here living for a period of time together, a minimum duration period, or having a child. Now, the go-to source of inspiration naturally would be the de facto regimes in New Zealand and Australia here. So with Australia, you've got a statutory list of factors under the Family Law Act 1975, section 48A2, and that looks at duration of the relationship. It looks at whether a sexual relationship exists, financial support, ownership of property, care and support of children, reputation and public aspects of the relationship. And you come within that definition, and then you look to see if there are eligibility criteria and if that's been satisfied. And that would be either total period of the relationship being 2 years, having a child together, the parties have registered their relationship. So in some Australian states, you can actually register, or the applicant has made a substantial contribution to the party's assets or the welfare of the family, and the failure to make an order would result in serious injustice to the party. So there you've got really a distinction that's drawn between a cohabitant and a qualifying cohabitant. And the Irish regime is quite useful with that distinction, the 2010 regime that Catherine will talk about later. There's a different way of looking at it in Portugal, and Portugal uses a statutory framework, but a distinction is drawn between positive conditions and negative conditions. So the positive conditions are essentially bed, table, and household. So you look at the quality of the relationship. And then you have the negative conditions basically stating you must not be within the prohibited degrees, you must be of a certain age. Sometimes we see that you have definition plus satisfying one of the eligibility. And other jurisdictions have more of a cumulative approach where you have to satisfy all aspects. And Croatia has an interesting one here with a cohabiting relationship. So you must fall within the definition. And then for the mixed sex regime, you must be of different gender, free marital status, relationship of 3 years, and also there's a child element too. Some adopt a shorter definition too. So if you don't fall within, say, a 3-year period, you may also be able to fall within a short duration relationship. That happens sometimes in New Zealand. And others have a shorter definition of cohabitation too. Yes, shorter definition. So Scotland, if you look there, it doesn't have the same detailed regime as Australia, but section 25 does suggest a few qualities that you look at to define a relationship. Some jurisdictions have very little statutory guidance and they rely heavily on the judges. And this is a position that we see quite clearly in the Netherlands. The Netherlands has multiple definitions of cohabitation, so much so that the legislature was actually going to try and remove them and harmonise, but said it was too difficult, and it hasn't actually happened. Poland, China, Chile, Greece all have judicial statements and definitions of cohabitation, but they don't have a detailed statutory definition as such. And if you look at Israel, the Supreme Court there embraced some of the ideas that we have in England and Wales, saying it's too difficult, and that actually defining a cohabitant under Israeli law has been compared to as being as impossible as squaring the circle. Complicating factors, as I mentioned earlier, is where you have got multiple jurisdictions. So the US, 50 different regimes of de facto, Mexico, Spain, Canada, all with different positions. So you have to be aware of different state province law. Another feature that we notice is that some countries operate multiple definitions simultaneously, and that can be a bit confusing. New Zealand has a definition of cohabitant under the Legislation Act 2019 that applies often for kind of social security benefits. And then they also have a definition of cohabitant under their Property Relationships Act 1976. And so you've got to be able to navigate those two aspects. I want to mention a few interesting examples of eligibility criteria too. So Slovenia, Macau, Portugal also have interesting negative requirements, basically saying that you will not be recognized as a cohabitant if one party has a mental disorder, severe mental illness or dementia. And Portugal slightly modifies that by saying that it is permissible if the dementia occurs after the relationship. And my particular favorite would be Portugal, that basically stops cohabitant recognition if one of the parties was a perpetrator or accomplice of an intentional murder, even if not committed against the spouse or the other cohabitant. So moving then on to gender. So gender, as Jens said, highly dependent on the country's approach in relation to same-sex relationships. If you've got a civil partnership or registered partnership regime, you're more likely to embrace same-sex cohabitants, even better if you have same-sex marriage. Some states will expressly regulate the gender requirement. Others basically have a mixed-sex requirement. And then we've seen constitutional or discrimination law-based challenges that have then allowed the courts to open up that definition to same-sex couples. So Brazil would be an example of this. So generally, we do see this trend of degendering happening in relation to de facto recognition. A curious creature is Croatia, because they have two regimes that are parallel. So it's a bit like our same-sex marriage or marriage and civil partnership regime, virtually identical entitlements, but they have kept these systems very separate so that you have a life partnership regime for same-sex couples, and then you also have a parallel regime for mixed-sex couples. Fiji, we found, was quite an interesting country when it came to gender. The reason being is that they absorbed a lot of Australian law. However, they limit the regime to mixed-sex couples only. However, same-sex couples are recognised for other purposes. And this is where you have someone who's in receipt of maintenance. If they start cohabiting with someone of the same sex, they lose their maintenance entitlement. So Fiji is an odd, curious jurisdiction where in some instances you're recognised, in some instances you're not. As to age, we have some that have explicit age rules. So you must be of a certain age before you're even recognized. But again, that issue where you've got multiple definitions causes a problem. So in New Zealand, you have the Legislation Act, which requires 16 years of age. And then the PRA, the Property Relationships Act, that one requires couples being over 18. Where it's silent, we find that the age of majority is often used as a benchmark. Alternatively, you have to be of marriageable age, or sometimes we use the criminal law. And so basically say the cohabiting relationship's not going to be recognized if for some reason the relationship would be prohibited. Some don't recognize or even state the age requirements. The Commonwealth definition in Australia doesn't. And that does sometimes mean that relationships with minors could actually technically be considered de facto relationships. And that would be the position in Jamaica and also Trinidad and Tobago. We didn't look at that, but in Trinidad and Tobago, under their regime for de factos, one of the factors a court can take into account is whether the age at which the parties started cohabiting and whether or not it was underage. Some countries actually are wanting to specify an age and be more concrete, and I believe that's part of the Scottish Law Commission's review there, looking to insert an age requirement. So moving on then to consanguinity, affinity, and conjugality. So some jurisdictions will have express prohibitions saying that you cannot be in the prohibited degrees in order to get recognition. Others leave it implicit. So Greece is an interesting example here for the definition of a free union developed by the courts here. There's no explicit mention whatsoever, but it's implicit in the court's reasoning that they're looking for a conjugal intimate relationship. Japan is interesting here too, because Japan has certain entitlements that are restricted in the sense that the prohibited relationships can't come in. But in other contexts, social security, for example, the courts have been a bit more flexible and have allowed relationships between siblings to be recognised. So when we're looking at how we kind of filter out, as Yen said, certain relationships, the marriage comparator creeps in quite a lot. It's a useful way of saying this is the relationship we want to prioritise. And if the further away you are from that marriage comparator, the less likely you'll get any recognition. Ireland does this in the sense that with the 2010 regime, you must be able to marry effectively in order to get recognition there. And Scotland has a very strong use of a marriage comparator, as I'll mention later. Conjugality is another means of ruling out certain types of relationships. So in Israel, sexual intimacy is quite useful in terms of proving the existence of a cohabiting relationship. And Ireland has a curious provision that basically says that if a relationship stops being sexual, it doesn't preclude that relationship actually being recognised as a cohabiting one. So in a way, sexual intimacy sometimes is useful to strengthen that idea of togetherness, and it's not always conclusive. Variations again occur in certain jurisdictions. So Mexican City does not require sexual relations, but other Mexican states do require it to be intimate and sexual. Looking now at living together and this particular criterion, some jurisdictions require it as an essential factor, and it really goes to the core or the essence of what it is to be a cohabitant. You must live together. Strict approaches we can see in Scotland. There's some decisions, Gutcher and Butcher in 2014, basically saying that living apart may not necessarily give recognition, but I don't think it's a complete exclusion of those types of couples. You get a softer approach happening in other countries. So Croatia, you can live apart, but it does sometimes mean that your claim to be a cohabitant could actually be weakened, and it would be better for you to show those ties in order to get recognition. Under the French regime too, underneath the Pax, you need to show a life in common, and it's less likely for you to do that if you're not living together. Some countries have allowed for living apart, and even expressly stated that if you do live apart for a period of time, that will not preclude you from getting recognition. So under Norwegian law, there's a specific provision saying that a cohabitant will not lose their status if they live apart due to education, work, illness, institutional stay, or other similar circumstances. As I said, we found quite interestingly the tests that were developed to prove living together have often been borrowed from divorce and marriage. So we've got the triple communion of Portugal, the bed, table and household. And then also in Poland, what we're looking there is what's called the doctrine of free bonds. So is there a mental, physical, economic tie? The marital comparator is something that crops up quite a lot. So with the marriage comparators, we've got some that will use an express reference to marriage. And England is quite an interesting one because we see a gradual process in our understanding. We have had living together as husband and wife, living as if civil partners. And now we have partners in an enduring family relationship for the purposes of adoption and parenthood via surrogacy. So we're shifting from marital to neutral. Ireland also did something similar. So Ireland has a slightly different position because of the constitutional protection of marriage. Ireland, the Law Reform Commission of Ireland wanted to insert marriage-like into their regime, but then that was rejected because it would get tangled up with marriage. And so under the 2010 regime, it's living together as a couple in an intimate and committed relationship. Scotland is also, again, another interesting jurisdiction, and we're going to be hearing about that more in Kate's presentation. And Scotland's wanting to shift from the marital comparator to one where it is now living together as a couple in an enduring family relationship. So that process of removing that direct link. Canada is an interesting country in the sense that what we see is quite a bit of variation, but there is a strong drive towards the marital relationship there. You've got explicit references to the couple living together in a marriage-like relationship in British Columbia. In Quebec, you have to be living maritally, and those are explicit references. And then there's implicit references through the courts. So Ontario, the word cohabitation has been interpreted in a way of basically looking for whether the relationship is sufficiently spousal. And so here we have that issue of whether or not normative ideas are going to be brought in when the court is looking at this relationship. Are they effectively looking for mimicry of marriage? More interestingly, and Jens alluded to this in his presentation, Japan is a fascinating report and certainly one of my favorites in the project, because in the 1950s onwards, Japan developed some recognition of de factos, and the courts created a concept of quasi-marital relationship and would give it significance. They also borrowed breach of promise and effectively said that an individual who was jilted, for example, could be claiming damages as a result. So a direct allusion to that marital link. Strong marital comparators also happen where you've got a religious influence, particularly the Catholic Church. So if you look at Portugal, living in conditions analogous to marriage. Brazil goes one step further. Brazil actually has a law that says that you should basically be encouraged to convert your de facto relationship into a marriage. So as I said, this comparator has multiple functions. It's about working out who we like, who we dislike, who we want in, who we want out. One final point is to mention Israel here, where Israel even has, they've now changed this position, had this idea that the couple had to be mistaken to be married. So when they held themselves out in society, they had to be mistaken to be married. That's now softened though. Okay. Minimum duration. So again, lots of variation here. And the reason why there's variation is all dependent on whether you've got a specific regime, a de facto regime that you want to use, or it's dependent on a specific legal entitlement. So if you want to adopt, for example, or if you want to have a residence. So Portugal would be a good example to use here. Under their de facto law, you can be living together for 2 years to obtain certain benefits. But if you want to adopt, you have to be together for 4 years. And if you want a non-resident seeking Portuguese nationality, you have to be living together for 3 years. Again, Mexico crops up as another interesting and quite complicating country in the sense you've got multiple different time durations happening across the states. So 2 years generally, but there's also 1 year, 3 year and 5 year in different states. Some do not impose a time limit. And an example here would be Scotland. So Scotland doesn't have a minimum duration of cohabitation, but as we know, only certain types of relationships tend to cross the threshold, and they're often quite lengthy and committed ones. A short transient relationship is sometimes unlikely to be able to get any recognition. Now, there are obviously debates about the duration period, whether or not it works, whether or not it's too arbitrary. And our Croatian report talked about how their minimum duration of 3 years is sometimes too rigid, and they actually would prefer to get rid of the duration requirement and leave it up to judges to then work out which relationships should be accorded any recognition. Children, quite interesting. We're not going to talk about that. I'll hand over to Jens a little bit towards the end, but children have quite an unusual role because, as we see sometimes, if you have a child, you have immediate eligibility in some schemes, or what it does in Ireland is reduces the time that you have. So in Ireland, you have to be together for 5 years, but if you have a child together, you can claim after 2 years. Children also is very important when it comes to definition. It goes into the stability of the relationship and the idea of commitment. Nigeria was another report that we looked at, and in certain sections of Nigerian society, what we saw was the childbearing cohabitant actually was treated more as the actual wife than the childless wife, which is quite interesting. That's showing the value that was attached to children. So concurrent relationships now. So concurrent relationships is where you effectively have got a overlap. You might have a de facto claimant and the partner is in a marriage or a civil partnership, or you might have two overlapping de facto relationships. Now, some countries, and this is the general rule, they don't really confront this issue. They don't want to go into it. And there's often limited recognition or even discussion. Others expressly reject the ability for you to claim if there's a pre-existing relationship in existence. We see sometimes we have a statutory prohibition saying that you're prohibited. The de facto partner must not be married or in a civil union, but it's also implicit when you use the marriage comparator. So if the relationship is it with another party, then your relationship might not necessarily have that quality of being marriage-like. So Brazil has an explicit block on the ability to recognize a concurrent relationship. And if there's two de facto relationships in Brazil, the first in time is the one that is recognized. Others allow, but they take a very kind of fact-sensitive, holistic approach. And Japan is quite interesting here. What the Japanese courts have been doing is looking to see the status or activity of the relationships. So where the pre-existing marriage is effectively dead, then they're more inclined to recognize the cohabiting relationship. Israel also has a slight nuance to this in relation to the ability for to obtain a divorce under religious law in Israel. And so if you've got a partner who is a wife, she might be able to get de facto recognition, even though she's still married to her husband, partly because of the restrictions that are imposed on her in order to secure a divorce. So there are some culturally and sensitive issues there. Right, so contracting in and contracting out, so the bit of the okey cokey. So we've got some countries that allow you to enter into a de facto regime, to fast track essentially what your entitlements are. So opting in is quite interesting. It applies in certain Australia states, it applies in Catalonia, where you don't have to satisfy the minimum duration period. You can fast track and get entitlement. And it's often done for the benefit of giving legal security. You have legal certainty in the sense that you know that you're protected by this regime. But generally speaking, it's quite rare. Now, Malta, I have to say, is one of my favorite reports, partly because it's had such a tortuous journey of recognition and now no recognition. So Malta had a cohabitation law in 2017, and it regulated in this act 3 different types of cohabitation. De facto, it had cohabitation by means of a deed, and then a unilateral declaration form of cohabitation. And then in 2020, this new Cohabitation Act got rid of that. It abolished unilateral declaration and also abolished de facto. So this means that there's no true de facto protection anymore in Malta. So Malta, the only way in which you can gain recognition is through the parties entering a contract or deed. So there's a curious idea where most countries are trying to recognize de factos. With them, they did recognize de factos and then took a step backwards, arguably. So we have contracting out, and this is more common. So this is the ability for you to disapply some of the rules and entitlements that you get. Naturally, there's limits here, as we have in England and Wales. You can't contract out a certain taxes, social security, for example. You can't use private agreement. But in other countries, you could use an agreement to try and contract out of what you would get under a regime. So you could contract out of the sharing of cohabitation property under the Swedish Cohabitation Act. You could reject the deferred sharing principles under the relationship property regime under the PRA in New Zealand. And you can reject the default property regime in Brazil. But we did see quite a bit of variation as to what you need in order to actually disapply the rules. Was it light touch, or did you really need to comply with a lot of procedural requirements here? So do you have this just basic contract law rules need to be followed, or do you need to go further? Do you have to go into independent legal advice or a declaration that one person has waived their access to legal advice? So some countries go into more family law sensitive checks and balances there. Okay, so legal effects during the relationship, and this is looking at property and maintenance. I'm not going to go too comprehensively into this, but generally speaking, the existence of a de facto relationship doesn't give much in terms of a status during the relationship, whilst the relationship is intact. So what we find here is, so England and Wales, if you are cohabiting, no property regime, separate property applies, no statutory home rights, no protections against third parties, no expectation of contribution to the household. Same would apply with Ireland in the sense that you have no property right to change, no presumptions apply, and the protection of the home only applies to constitutionally protected relationships, i.e. married couples. It doesn't apply to cohabitants. There are some variations on this. So New Zealand, for example, operates a deferred system of relationship property, and that tends to spring into being upon relationship end. Obviously, it's deferred. But you can actually restrain one party during the relationship doing certain things with the family home, alienating it, for example. So you can have some restrictions whilst it is intact. The same would apply under Jamaica, under the Property Rights of Spouses Act 2004. Quite a progressive act, because that introduced the ability for married couples to share the matrimonial home, but also their concept of spouse in Jamaica includes a de facto spouse. You have to live together for 5 years, and then you get subject to the equal sharing rule under Jamaican law. And in Jamaica, you can actually restrict transactions happening to the matrimonial home and stop one person alienating it. When it comes to maintenance, most countries do not have a maintenance obligation during the relationship. Western Australia has a slightly different approach. It does allow you to enforce spousal maintenance during, but most often it's upon separation. New Zealand, curious. New Zealand, you can't, as a de facto, enforce maintenance during the relationship, but if you were a spouse, you could enforce spousal maintenance during the relationship. So that's a rare example in New Zealand where you have a slight distinction drawn between spouses and de factos. So just wrapping up in a few slides, we've got some other rights. Other rights was really a miscellaneous category of rights that we wanted to look at. We looked at domestic abuse, visitation, the ability to visit people, nominations if one person was incapacitated, social security tax, and this really did show a lot of different variations. What we tended to see is that domestic abuse protections often were extended over to de facto partners, and India is a fascinating country there, because a lot of their de facto recognition comes out of the Protection for Women from Domestic Violence Act 2005. So their cohab regime, really, if you can call it that, is born out of that context of domestic abuse. Visitation, often you had countries saying that you can visit someone in prison or hospital as a de facto partner. And in terms of medical decisions, that was often permitted, but there was a clear preference for nomination, ensuring that this person is able to take decisions on your behalf. One curious thing I found was Brazil. Article 14 of their constitution bars spouses, relatives, and de facto partners from holding political office to stop, obviously, concentrations of political power. So an interesting incident there. In terms of differing treatment, as I said, we see quite a variation with tax, immigration, workplace benefits, and social security. Contracts and the ability to use a contract to regulate. Contractualization was found to be really key in certain countries. The USA, for example, following Marvin and Marvin, strong push towards parties self-ordering by contract, and it's also the case in Belgium too. Evidence of contract law restrictions was certainly there. So you do need to basically satisfy general contract law, or do you have to go into more specialized family law when it comes to regulating these contracts? So, for example, could these contracts be struck down for certain more family law ideas, such as injustice, failure to disclose assets? And there was variation. Some countries have strict, quite public policy, ordre public prohibitions. So Nigeria, there are contracts being entered into there, but there has been some reticence on the part of the courts to recognise them, a bit like the public policy objections that we had before, say, Sutton and Mishcon de Reya here. And Poland has some slight pushback in relation to contracts, partly because Polish law is questioning whether or not you should be able to use a contract to create effectively matrimonial consequences, whether or not that should be the seat of any form of recognition. In terms of separation, we've got termination. Termination was quite straightforward. So with a de facto relationship, there's obviously no divorce or dissolution. It's walking away generally, unless it ends via death. And we saw that it was naturally very informal, no real procedure to be followed. But some states do regulate precisely when it's seen, or when a cohabiting relationship is deemed to have ended. So Sweden's Cohabitation Act requires marriage, living apart, and when one party applies to court for the appointment of a property distributor. Mexico also will state that termination will be based on marriage, mutual agreement, or separation for a certain amount of time. So if you're separated for 3 months, in some states it's 6 months, you will be deemed to be out of your cohabiting relationship. With remedies, this is really difficult. And as Jens said, it was really a core focus of our project because there's an infinite variety. And naturally, it relates back to qualifying criteria in the sense you want to ensure how do you define the qualifying criteria and what do you get? Do you get deep, intense property rights, or is it a more low-level compensatory personal type remedy? So in some, we've got a community of property that springs up and arises. Others have rule-based sharing regimes, such as the deferred community under New Zealand. Australia uses effectively their just and equitable jurisdictions that they use for divorce. That just applies quite seamlessly over to de facto couples. And the interesting feature there is that because that regime doesn't really have presumptions and principles specific to spouses, it was quite easy to just transfer de facto relationships into that framework. Others have more of a low-level claim that seems to be happening, a compensation or damages type claim. As I said, damages is particularly interesting when you look at Japan, that has a range of different actions that could be used. More commonly, we saw where the countries are not necessarily embracing cohabiting relationships, we've got general claims, contract, unjust enrichment, and also using existing general law and trying to familiarize it and tweak it. And we see that quite interestingly in Germany. We've got some question here in terms of hierarchy. Are certain relationships favored over others? Generally, we tend to see that marriage is prioritized, and that's specifically recognized in the Irish regime of 2010. So when a court is dividing there, they can take into account any rights, entitlements of a current former spouse or partner. So marriage is fitted in within that de facto regime. Others will basically struggle if you've got an existing marital relationship. Others will struggle to try and show the cohabiting relationship has the intensity needed to satisfy de facto recognition. Time limits, this is in terms of when you actually are eligible to bring the claim. Often this applies when the relationship ends, and we've got shorter time limits applying in certain countries. Scotland is naturally reviewing or has reviewed the time limit there, the 1-year time limit, and now is looking to allow out-of-time applications and allowing parties to increase this by 6 months by private negotiation. In terms of then additional claims, this is my final slide, we have got some division in terms of how far the general law is there to support an existing comprehensive cohab regime. Sometimes it does support. And in Ireland, for example, you're actually encouraged to take out a resulting trust claim there alongside a claim under the 2010 Act, because it might actually strengthen your chances of recovery. Sometimes you have to use an additional claim because the property that you're dealing with falls outside the cohab regime. So in New Zealand, if you've got Maori property or Maori land, or equally if you have foreign immovable property, that doesn't fall under the PRA. It has to be dealt with via a separate general law claim. And we also see general law generally having quite a role to play if the individual falls outside the regime. So a same-sex couple in Jamaica would fall outside of PROSA and must use general law. And in terms of the jurisdiction, who hears these types of cases, we have got a bit of a distinction here. Where you have a developed system for de facto recognition, you tend to find family courts have the jurisdiction, but where you do not have de facto regulation, as you would expect, we're looking to the ordinary courts to really do the heavy lifting. Okay, I'll hand over now back to Jens.
Now to the bottom bump. And pleasant topics, death. Unsurprisingly, in many jurisdictions, the approach to de facto relationships ending through death of one of the partners really maps that for separation. So where there's an equation with marriage for separation, we also find this equation in case of death, meaning rights on intestacy and mandatory portions. So Slovenia, Croatia, Catalonia, and New Zealand. Where there's no such equation, it's actually intellectually more interesting, but there's some kind of recognition for de facto couples, and then some intestacy rights often follow. And where the couples are not recognized, unsurprisingly, this usually means they get nothing in the case of death either. So Germany, France, China, Spain, Greece, for example. But some trends actually can be observed. So the first trend is that jurisdictions that take generally a negative approach to de facto relationships seemingly are more inclined to be generous in case of death than they are in case of separation. So, for example, in most jurisdictions, this will include the right to succeed to a tenancy or rental agreement if it is the family dwelling. So that is not uncommon at all. Actually, it's very common. But sometimes this goes even further. So, for example, in common law jurisdictions like England and Wales, one could cynically say that it's financially better to lose one's partner through death than through separation, because you can actually make privilege claims against the estate. Other jurisdictions are not willing to go as far as to killing your partner, but will give tax benefits for the surviving partner, for example. Norway here is particularly interesting because here the rights on intestacy and related rights for de facto couples will only arise if they are or if they have or are expecting children. Otherwise, no rights. Another trend is that, at least as a starting point, there's a huge division between common and civil law jurisdictions because of the different approaches to freedom of testation and mandatory portions. Because in civil law jurisdictions, there's generally a limit to testamentary freedom. It's deeply ingrained in the culture. So even where there is a will, there's a minimum that certainly family members must receive the so-called mandatory or reserved portion. So therefore, the question is, in civil law jurisdictions, whether de facto partners should be among those that are actually benefiting from these intestacy rules and mandatory portion rules. And if so, should that then be the same as for spouses or not? And this is really closely connected to intestacy, because in civil law jurisdictions, it's usually the people who would inherit on intestacy who are entitled to the reserved portions. So these are fairly heavy policy decisions to take. In many ways, therefore, it's easier for common law jurisdictions because they can simply allow discretionary claims against the estate and without having to trouble themselves with intestacy in principle, although, of course, some common law jurisdictions quite rightly do trouble themselves with intestacy. We'll hear about that later. A final point on death, no pun intended. staunch defenders of autonomy, which very often hail from common law countries, it must be said, will of course refer to the fact that it's always open to de facto partners to make a will, and then everything will be fine. And of course, that's not true. It's true that they can make wills, of course, but the fine part is not so true because it very quickly reaches limits. For example, in civil law countries, when others can claim a mandatory portion, then of course you're very constrained with your will. And in most countries where tax is due to be paid for inheritance, the tax person will just come and take away up to 50% or even more in some jurisdictions. So the freedom of testation, therefore, is very limited, unless, of course, you take that into account. And so therefore, I would say that at the very least, jurisdictions should start thinking about inheritance tax benefits for de facto partners where there is a will and therefore a very clear expression of autonomy. So the autonomy argument simply does not fly in these situations, I would think. So indeed, some jurisdictions have introduced tax benefits for de facto couples, despite the fact that they do not recognize de facto couples as such. And I think that's an interesting finding. In some cases, of course, there are additional requirements. Right, on to the truly joyful topic of children, or as some call it, the greatest poverty risk you'll ever have, is with children, the question of follow or do not follow marriage pattern is really broken up a bit more, because thankfully jurisdictions increasingly realize that the child and their best interests should be at the center of the legal and policy considerations, and that the status of the parents' relationship really is secondary to that. So in many, many countries, de facto couples are treated the exact same as spouses when it comes to parenthood, adoption, fostering, and access to assisted reproduction. So Croatia, Norway, England, Spain, and so on. In Greece, very notably, only for opposite sex or mixed sex couples. So nevertheless, for practical reasons, I presume, and for evidence reasons, as regards paternity, the pater est presumption generally is not extended to de facto couples, but this can be dealt with relatively easily by the partner recognizing the child. However, with regard to parent responsibility, interestingly, the picture varies. So many countries still do not give both parents automatic parent responsibility from birth, but require the father to jump through various hoops of various sizes and various colors and various heights. But it's interesting to see that globally speaking, the resistance and indeed insistence on differential treatment of fathers based on the status of the relationship with the mother seems to be waning on the whole. So we have more and more countries moving towards, moving away from the model that only